Okay, Mr. Whitten?
Yes, good morning, Your Honors. May it please the Court, Jonathan Whitten, Barbara Huggins with me for the Town of Middleborough and Middleborough Board of Appeals, the plaintiffs' appellants in this matter.
Yeah, we're here on a limited issue, are we not?
We are, Your Honor. There was a petition to this Court for further appellate review.
Yeah, I know that. Confined to one issue.
Yes, Your Honor, and the issue being whether or not the New England Fund constitutes a valid subsidy pursuant to the Comprehensive Permit Statute.
Correct.
Your Honors, the Comprehensive Permit Statute requires a federal or state subsidy to be used in the construction of affordable housing for a reason. It is the assurance that the loss of local land use controls are balanced with a federal or state involvement and investment. The Housing Appeals Committee itself has held that a governmental agency with no financial stake in the development of affordable housing would have little incentive to ensure its success. Respectfully, Your Honors, the Appeals Court was incorrect to conclude that the Federal Home Loan Bank of Boston's New England Fund and its receipt of tax benefits constitutes the affordable housing subsidy required to be given to the developer of affordable housing. Your Honors, the New England Fund is not a housing program of the federal government as required by statute. The Federal Home Loan Bank of Boston is a private, for-profit entity that is wholly owned by its member banks. It receives no federal funding. The Federal Home Loan Bank of Boston's receipt of tax credits from the federal government does not and cannot constitute a subsidy as required by the statute. Your Honors, there is nothing in the record, nothing whatsoever, that suggests that whatever tax benefit the Federal Home Loan Bank of Boston might receive from the federal government is passed on to its member banks or, most importantly, Your Honors, to the developer of affordable housing units. Your Honors, the New England Fund is not a program of the state government as required by statute. There are no state dollars involved in the New England Fund. The Commonwealth of Massachusetts provides no financial assistance, no indirect financial assistance, no insurance, no guarantees, no in-kind assistance, no technical assistance, or other supportive services with respect to the New England Fund.
Can I back up to one point that you mentioned?
Yes, Your Honor.
You said that the receipt of the tax credits does not constitute federal assistance. Why doesn't it?
Your Honor, the Appeals Court held that the Federal Home Loan Bank of Boston benefits from a tax break, a tax credit from the federal government. There's nothing in the record below, and frankly, Your Honor, there's no evidence at all that whatever the Federal Home Loan Bank of Boston receives as a tax break is passed on either A, to its member banks, or B, most importantly, according to the words of the statute, to the end developer, to the builder of affordable housing.
So there's no evidence that in the record that the developer receives a pass-through tax credit?
That's absolutely correct, Your Honor.
Can we just trace the money now? It's the Federal Home Loan Bank giving it to the New England Fund, who then gives it to, I think it's Northborough Cooperative?
Slightly different, Your Honor. The Federal Home Loan Bank of Boston is owned by its member banks.
Right.
So the Federal Home Loan Bank of Boston has over 200 member banks in the Commonwealth. They would be the managers of the so-called New England Fund.
Okay.
And in this case, in the facts in this case, it's the Norwood Cooperative Bank.
That's a member?
It is a member, Your Honor. As of the issuance of the project eligibility letter in 2000, yes, it was a member.
But where does the money come from?
The money comes from its member banks. The Federal Home Loan Bank of Boston will pool its resources with its member banks, will then make loans to its member banks for a profit, and then its member banks will eventually make loans to...
Why did, this is kind of rudimentary, but why did they stick the word federal on this thing? The Federal Home Loan Bank.
Excellent question, Your Honor. At one point in time before the S&L crisis, the Federal Home Loan Banks were or had an indicia of the federal government. Since the S&L crisis, the Federal Home Loan Banking system is entirely private, and there's no dispute in the record, either in the record or at the appeals court level, that the Federal Home Loan Bank of Boston...
So if we pick our way through this kind of complicated banking situation, we will find tax subsidies to the Federal Home Loan Bank, and that's about it?
That's exactly correct, Your Honor. And the statute requires that the housing be built constructed with a subsidy, either federal or state. The New England Fund is anything but a federal or state subsidy.
I thought at one point the question of assistance also included technical assistance. This may be a historical thing, but and it was pretty easy to get technical assistance from like a regional planning authority or a local planning. Why doesn't that apply anymore?
Your Honors, this Court has held that the definition of subsidy should be liberally interpreted, and you've held that in Charles Bank, you've held that in Wellesley, you've held that in 40B cases. But in this particular matter, the Federal Home Loan Bank provides nothing, zero, to the developer of affordable housing. The member bank provides nothing, zero, other than a loan to the developer of affordable housing. In the facts before this Court, there is no technical assistance from the Commonwealth, no technical assistance from the federal government at all. No insurance.
Is there a federal charter of some sort?
Yes, there is, Your Honor. At one point in time, and after the reworking of the Federal Home Loan Banking System and the Federal Home Loan Board, the banks were entirely privatized.
So this is not a case where we can, in your opinion, where we can defer or give deference to, I should say, the decision of the Housing Appeals Committee, because you say they're just wrong.
Absolutely wrong, Your Honor, and the appeals court decision made that very clear, that the Housing Appeals Committee was propelled by policy interests, and that may be good for the Housing Appeals Committee, but it's incorrect.
Well, so is legislation. And if those policy interests behind the legislation result in regulations that are consistent, what's wrong with that? That's what legislation is. It's a reflection of policy.
Because, Your Honor, the Housing Appeals Committee decision in Steuborn was not a reflection of the statute, because the statute plainly and clearly says a federal or state subsidy. It cannot be reasonably argued.
But isn't there a regulation defining subsidy?
There is, Your Honor. It's 760 CMR 30.02, definition of subsidy and subsidized housing. And, Your Honor, what I was saying at the opening of my presentation, if I could go back to that, the Commonwealth provides not one of those indicators as identified by the definition of subsidy in 30.02. No financial assistance, no direct financial assistance, no insurance, no guarantees, no in-kind assistance, no technical assistance, no supportive services. And
or other similar. I mean, I'm sorry, I can't find the language. I had it a few minutes ago. I mean, I thought the subsidy language was a little broader than that.
Your Honor, it does say, or other similar services. That is correct, 30.02, 760.
Direct financial assistance, indirect financial assistance through insurance, guarantees, or other means. I don't know what the facts are, but I thought the whole issue here, or I thought that the assistance was below market rate loans. Is that not the case?
That is not the case, Your Honor. There's nothing.
So they are not below market rate loans.
There is nothing in the record that an NEF loan is below market rate. And in fact, Your Honor, the cobbling together of what the Commonwealth might do under 30.02 would be wholly inappropriate in the facts before this Court. Because in the facts before this Court, as my brothers have suggested in their briefs and in the amici briefs, this was what they've categorized as the old NEF, before there was any indicia of involvement by the Commonwealth. Now, under what my brothers have claimed is the new NEF, they claim to show a subsidy by involvement by Mass Housing, a quasi-governmental agency. But, Your Honors, there is no assistance, no subsidy, even with the most liberal read of that definition provided by Mass Housing.
Well, so is it the case that these loans could be obtained from anywhere, or that there's difficulty in getting these loans, and this New England Fund provides the mechanism by which loans that otherwise couldn't be obtained could be obtained? Wouldn't that be a subsidy?
Your Honor, I agree with the former portion of your statement, but not the latter. The former portion is that the issue is these loans, the way the program is structured, could be obtained from any place. They could be obtained from anywhere using the Commonwealth's argument. And the reason for that is the Commonwealth is saying that because Mass Housing provides a project eligibility letter, that constitutes the required subsidy. The money could come from a brother-in-law or from Fidelity Investments or from a hedge fund. And as long as Mass Housing does something with the program, that constitutes the subsidy.
So what's wrong with the appeals court reasoning? They point out that that these, and I'm oversimplifying here, but the Federal Home Loan Bank gets tax credits of two different kinds, right?
We concede that, Your Honor.
So that if you get a tax credit, you got more money, right?
Yes, Your Honor.
They therefore use this money to funnel it through the fund to do this kind of housing. Why isn't that a federal subsidy?
Your Honors, there's nothing in the record below, nothing, that suggests that the money ever leaves the Federal Home Loan Bank of Boston. There's nothing in the record that suggests that that money isn't used to benefit the Board of Directors. There's nothing in the record, no evidence. And even at the Housing Appeals
Not
Committee...
even evidence that developers and banks that do this kind of thing under 40B get more favorable rates of interest on their development loans?
No, Your Honor. There is nothing. There is published reports from the Federal Home Loan Bank of Boston, but there is nothing in the record, and upon information and belief in my practice representing cities and towns, that the developer does get a favorable rate. The fact that the Federal Home Loan Bank of Boston is the recipient of a benefit doesn't mean that it's giving that benefit away. The purpose of the statute was to ensure federal or state involvement to make sure that this removal, this abdication of local control would have this delicate balance. This Court has held that standard from 1969, since the Hanover decision.
But can we infer that this project is getting a benefit from the tax credits? Now, you said that it could go to the directors, but that means if it's going to the directors, that frees up a little bit money to go to maybe a riskier project.
Your Honors, I don't believe you can infer that, and the reason why is there is no proof at all, and what we've seen from investigations ongoing by the Commonwealth, there's no proof at all that the money either goes from the Federal Home Loan Bank to the end developer, or that money is being monitored or the federal government has any stake.
So you say, in essence, that the appeals court has made a leap of logic here that's not supported by the record at all.
That's exactly what we're saying, Your Honor. In fact, the appeals court decision, in our respectful opinion, was 99% correct until the last couple paragraphs when
That's when it takes a turn.
Yes, Your Honor, and it does take a turn. It made a leap of faith by saying simply the receipt of tax credit would constitute a subsidy under the statute. And, Your Honors, the appeals court in a previous case had held that the subsidy has to be received by an individual.
What's the remedy here, if we agree with you? Send it back to the committee and say, okay, take further evidence about how these banks operate, and if you can identify and segregate and trace and link a nexus between those credits and what these developers are getting, you're all set?
Your Honor, that is one remedy, a remand back to the committee. What the town has asked is a remand back to the trial court. A third remedy is to overturn the Superior Court, because not only is there no evidence, but there is no connection to a federal or state subsidy.
All right, let me ask you this, though. I mean,
course, Your Honor.
the Housing Appeals Committee has already decided the question of whether the NEF qualifies, right?
That's correct, Your Honor.
So they've already decided that, and the language is, under the NEF, the Federal Home Loan Bank of Boston advances funds to one of its member banks, which in turn makes a construction loan to a developer at below market interest rate. That's a finding they made in a case just a couple of years ago. Was that finding simply without factual basis?
That is correct, Your Honor, and it's also incorrect. That is an incorrect finding. And
so this is another case that they've made this finding, and you're saying it's just incorrect.
Your Honors, the Housing Appeals Committee, since the Stewborn decision in 1999, has held consistently that its own prior judgment is correct, and that's not surprising from an administrative body's perspective. Only 3 years prior to 1999, the same entity, the Housing Appeals Committee, ruled that the New England Fund was not a valid subsidy program.
Correct, and it required certain adjustments to be made in the eligibility guidelines of the fund to ensure that, in fact, it would be loaning money to build affordable housing before it could become, before it could qualify, and they did that.
Your Honor, the Housing Appeals Committee did that, but the New England...
Well, no, the New England Fund did that.
No, Your Honor, respectfully, that would not be correct. The New England Fund has not changed.
All right, it says the New England Fund eligibility guidelines were modified to refer explicitly to affordable. So all this is untrue. This prior decision of the board is completely untrue, baseless.
The appeals court held so, Your Honor.
Well, they sort of said we're not persuaded by the arguments, but does that mean they were factually wrong?
There's nothing in the record to support the Housing Appeals Committee's conclusion that...
In that case?
In Stewborn and yes, Your Honor, I mean, Stewborn is the key case because that's what shifted the Housing Appeals Committee's position. But there's nothing in the record relative to Stewborn or the appeals court below that suggests that the dollar benefit that the Federal Home Loan Bank of Boston might receive is ever passed on to the developer of affordable housing as required by the statute.
Why isn't that a legislative fact found by the Housing Committee? the decision in the Stewborn case, doesn't that apply to all other cases unless it's proved wrong?
Certainly, the administrative body has the presumption of, or great deference from the courts. The Superior Court gave it that deference. The Appeals Court did not. So the Appeals Court held, at least respectfully, my read of the Appeals Court decision is that Stewborn was based on policy, not law, and then the Appeals Court held that, but there is a federal tax credit, therefore there is a subsidy.
Mr. Whitten?
Yes, Your Honor.
Your time's up.
Thank you, Your Honors.
Thank you. Okay, Mr. Cray, how do we get this nexus that we obviously need to get?
Well, Your Honor, I first may please the Court, Pierce Cray, Assistant Attorney General for the Department of Housing Community Development and its Housing Appeals Committee. I'd like to first, if I could, just notice how often, both in the town's briefs and in this oral argument, the phrase "nothing in the record" or "no evidence" was announced. There's a reason for that. The town never raised any of this before the Housing Appeals Committee in this proceeding. Instead, it has come in here to this Court on further appellate review for the first time, putting in lots of new extra record factual materials to support the arguments that they're now making. And the town
came into the Appeals Court first.
Pardon, Your Honor?
The Appeals Court.
None of this, none of the new factual materials that are appended to their brief and that we have moved to strike, none of those were submitted to the Appeals Court. So the arguments, the new fact-based arguments are being made here for the very first time without giving. I don't believe these arguments, the ones he's pressing so strenuously today, were even made in the Stewborn case. So this
Well,
is.
let's take them out. We still have an Appeals Court opinion, as I read it, that struggled mightily to find a connection, and ultimately did so, and maybe I'm oversimplifying, by focusing on these credits.
Yes, but it did so, Your Honor, without the benefit of any factual findings on these points by the Housing Appeals Committee or any application of the committee's expertise in this area. And there's a basic principle of waiver that should be applied here. Now, I know there's been a little dispute about exactly what the town didn't raise for the committee. I would submit that it should be clear that as to this specific issue, whether or not the New England Fund's projects are housing subsidized by the state or federal government, that was at no point raised before the committee.
So you're saying that the Stewborn case, the precedential value of the Stewborn case is really something that we can rely on?
It is, and to the extent to which there are new arguments that should be made to attack that, they should be made in the first instance before the Housing Appeals Committee and supported by evidence there.
In another case, but not this one.
Absolutely. That's the basic waiver rule, is you should not waste an appellate court's time without having put your evidence in below and had it evaluated by a fact finder.
But certainly the issue must have been raised.
Not before the Housing Appeals Committee.
Then why does the appeals court take so much time deciding it? Is it just they pick it up?
Let me also be. We're not entirely without blame here. The waiver, the argument that things had been waived, was not directly pressed in our memorandum before the Superior Court.
So did you waive your waiver argument?
We argue that it did not. The basic rule is that, and the Superior Court found in our favor, and that judgment can be affirmed on any ground apparent in the record. And while it wasn't in the Superior Court memorandum that was submitted, it was squarely on the face of the Housing Appeals Committee decision. If you look at page 5 of the record.
Raised in the Appeals Court with the same vigor you're raising it here today?
So, I joined the case fairly shortly before the Appeals Court argument. And at that point, I started off my oral argument with the waiver point. Mr. Whitten has not contested that. It was not in the prior brief made. It was apparent on the face of the actual administrative decision under review.
The Appeals Court doesn't talk about it at all.
Pardon, Your Honor?
They don't talk about it at all.
I know, and in fairness to them, the argument had not been was not in the brief. It was the lead argument I led off with at oral argument, and but I'm saying for this court, for the Appeals Court and for this court, you can affirm on any ground that is apparent on the record.
Let's look at the other side of the coin. Let's assume for whatever reason we don't accept your waiver argument. Where do we stand then?
There's a second very simple, straightforward basis for resolving the case, and it's one the Superior Court did rely upon. And I direct the Court here to pages 31 and 32 of the record. And that goes for the fact that the department that lay out how challenges of this sort to the fundability or the appropriate funding of a project should be handled. They provide that if a so-called project eligibility letter is introduced into evidence, that creates a rebuttable presumption of fundability, which encompasses both the argument Mr. Whitten has been making and a whole range of other points. Here, both the Housing Appeals Committee and the Superior Court specifically found that there was a project eligibility letter submitted in evidence. That would be pages 5 and 31 to 32 of the record appendix.
So that creates a presumption.
That creates a presumption, and there was
that wasn't rebutted
in any way whatsoever at the before the Housing Appeals Committee on the issue of the legitimacy of the NEF program. And the town has made no claim in its reply brief that it rebutted the presumption. To the contrary, its briefs are full of statements that there's no evidence. And that was repeated in argument.
So
that only goes to show they didn't satisfy, they didn't rebut the presumption.
If we agree with you on one or both grounds, this is a rescript.
Absolutely, Your Honor. But it is one that would have significant importance. The reason being that the appeals court opinion, while we prevailed and it found the reasoning in the appeals court's opinion cast significant doubt on many other major affordable housing programs that were not before the appeals court and that were of significant public importance, ones that involve non-financial subsidies.
Well, certainly non-financial subsidies that fall within the regulatory definition of subsidies would qualify.
Yes, but, Your Honor, because
and did this opinion to undercut that?
Yes, it would. I mean, the opinion did not address, the appeals court did not address the effect of the regulation at all, the regulatory definition of subsidy. It referenced it, but didn't affect it. And we respectfully think that should be the first place one turns after you look at the text of the statutory language. Is there a valid regulation construing it? So, but what I'm saying is that this because the appeals court made that decision, reached that without getting into the regulation or addressing it, there has been substantial uncertainty created about these other very significant programs.
And all of these projects are in the pipeline?
Yes, especially the ones that are the most current. Now, this project is under an old form of the program that there are not as many left in the pipeline. But the ones that are primarily the biggest ones now, or among the major players now, do directly involve non-financial subsidies. And there is language in the appeals court decision that creates substantial uncertainty. The best evidence are the lengthy and detailed amicus submissions that the court has received from the development industry and from things. So this, again, just goes to show this is an area of very high public interest. On one of our Commonwealth's most pressing needs, our affordable housing crisis. Certainly, an issue of this significance that will call major parts of the affordable housing market into question should go according to the ordinary procedural rules, where you raise something before the fact finder that's charged to decide it.
So you want us to do two things if you prevail. One is to say waived, and that's why you prevail, unless it's on the procedural rule. And two, this part of the appeals court opinion is wrong?
Sure, I think
shouldn't be relied on?
If the court chooses to affirm on any of the two alternative grounds I have laid out, waiver or the effect of the presumption that was not rebutted, and I've cited both at length in my brief. If you choose that, then the appeals court opinion will be superseded by this court's opinion. Its precedental effect will no longer be there, and the substantial uncertainty that's right now pervading the industry will be removed. Certainly, the issue is still going to be out there, and Mr. Whitten can press it in another case later, but you don't have the effect right now of an appellate precedent that obviously everyone needs to give.
Well, we would, if you prevail, we would be better perhaps to say something about it in the sense of we don't address at this time.
Absolutely, Your Honor.
This business about.
Absolutely, Your Honor. And certainly also the fact that there is this regulation that defines subsidy that is not being challenged here as ultra vires. It's not being challenged as beyond the Commission's authority. It was laid out in our red brief, and no rebuttal made that it was exceeded any challenge of being ultra vires. That should be the controlling legal standard in any future proceedings going forward. A very broad definition that actually followed a recommendation by a commission specifically appointed by statute around 1989 that recommended a broader definition of subsidy for a variety of reasons.
Can I ask you this? Let's go back to the regulations, 3101. There's no mention of presumption in there. It simply says fundability shall be established by submission of a written determination of project eligibility by a subsidizing agency. All right, who's the subsidizing agency here?
Our position would be, in that instance, it would be the Federal Home Loan Bank system as a whole, with the specific entity immediately transferring the money. In that event would be the Norwood Bank.
And there was a written determination under this regulation in this case?
Yes, it appears at page 24 of the record. And again, this is not the validity of that letter has not been challenged in any judicial proceeding.
24 of the record or the appendix?
I'm sorry. This would be the separate white record appendix.
Okay.
RA 24.
And how many pages is that letter? Does it go through all of these?
It's a short letter. Actually, note, at the time, the regulations of the department about a project eligibility letter were just said the letter simply had to note that the project, a determination the project was eligible.
So there's a different regulation that applies to this letter, to this project, than the one you've directed us to?
No, an earlier version of that was what governed at, it's the same regulation. It's had different iterations at different points in time.
Where is that in the record? Where's the version that would have governed this project?
That is not, it's not, but certainly it's judicially noticeable. I'd be happy to supply it.
No, I'm just saying that what you've provided us is a very extensive set of items that need to be included in this written determination of project eligibility, including fundability, which suggests that a one-paragraph letter would never qualify. So, but you're saying that this
it was valid.
Necessary.
It complied with the form of the version of the regulation that existed at that point. And there was, again, no challenge made at the committee level to the letter on that basis. So again, the Superior Court accepted the letter as an appropriate funding eligibility letter, and again, it just goes to point out that there was nothing rebutted. Now, Your Honor talked about presumption. The presumption language.
Well, I'm looking at the wrong regulation, obviously, because this is not the one that was in effect.
Well, it's an earlier version of that one, but the presumption language appears in 31.07.
Oh, so that's on another page. That's several
That's right.
pages. Okay.
And specifically 1A and 4A. So those are where the thing. And again, our position, the easiest way, this is something you don't have to get into the waiving waiver questions or the like, although we submit the court is fully able to make a waiver ruling. But the Superior Court relied, it was one of the bases, two bases for its ruling, was this project eligibility letter, and that is a fully sufficient basis to get into it. I think a case of this magnitude, to start at this level with submissions that are coming in on further appellate review, inherently one-sided, that's the nature of the adversary process, is simply not an appropriate way to approach something of this magnitude. And indeed, if the court were to reach the issue on the basis of all these new submissions, that might inadvertently encourage other appellants to violate the rules on extra record submissions in the hope of either determining, either obtaining a ruling by the court or a remand. And again, we oppose remand as a primary resolution. It should be either, it should be simply affirmed on the two bases that we've sought. If the court wants to provide guidance about the regulation being the starting point for any analysis, and I mean regulation here, I'm talking about the definition of subsidy that Justice Corey's been asking questions about, that should that certainly would be appropriate to help guide everyone as they go forward. But our view is that this is a very important issue, and it should go through the usual processes before making a final resolution.
Okay, thank you. Mr. Whitten, I know there's no rebuttal. You can send us a Rule 16A letter if you want to respond to the waiver business and so forth. Okay, we're going to take a short break.